resources we devote to ensuring that all those who commit serious white-collar crime are caught and are punished. For reasons that have to some extent been laid out here today, and which I explore more in my written statement, in the United States, the federal government is the primary, and in some jurisdictions, virtually the sole investigative and prosecutive authority for complex economic crime. I would submit that the most valuable thing that this subcommittee and this Congress could do to fight white-collar crime in America would be to appropriate and dedicate additional funds for the Justice Department and the regulatory and investigative agencies who fight white-collar crime.
Thank you for a very thoughtful statement. Appreciate it. Mr. Rosenzweig.
Thank you, Mr. Chairman. As you said, my name is Paul Rosenzweig, and I work at the Heritage Foundation. I'm also an adjunct professor at George Mason University, where I teach white-collar and corporate crime. So this is a subject near and dear to my heart. I also find myself quite comfortable as the last on this panel because that position will allow me to be brief. I find myself in agreement with much of what has been said already. I concur wholeheartedly that some of the problem is the lack of devotion of resources appropriately to the prosecution of white-collar crime. I agree as well that part of the problem is the intricacy and difficulty of proving those crimes, and that is perhaps something inherent in the nature of white-collar crime that no act of Congress or the Sentencing Commission and no devotion of greater resources can or ever will solve. When and if there is ever a trial of a fraud of the size alleged potentially against Enron, that trial will occupy a court and a dozen prosecutors for nigh on 6 months, and still may be impenetrable to either the judge or the poor jury, obliged to sift its way through the intricacies of the finances there. I also agree with Professor Bowman that for the most part, the sentencing guidelines have moved substantially in the direction of making more equivalent white-collar and street-type crimes. The 2 points that I would add that are perhaps different than those that have already been brought forth are these. First, to some degree, I think we need to absolve the courts of responsibility for such disparities as remain. Much of the cause of that lies not with them, but either here in Congress or in the guidelines themselves. In my written statement, I provided you with some information about the rates of imprisonment that are given to defendants in situations where judges have discretion to choose either imprisonment or some non-imprisonment type of punishment, home detention, community service, probation, that sort of thing. And if we look at that data, we see that in those situations where discretion remains in the district court judges doing sentencing, for the most part, the rates at which they impose imprisonment don't vary that much based upon
is that your chart on page 6?
That would be the one on page 4 that I'm looking at.
I'm sorry.
The rates of imprisonment. We do see that that drug traffickers get people.
Yes, I have a different pagination.
Okay, it may very well be that I submitted it by electronic mail and the pagination may have changed. I apologize.
Is it the first
yes
chart you have where it says crime type, rate of imprisonment, fraud, larceny, immigration, etc.?
Yes.
Okay.
But as you can see, that applies to only some 11,000 individuals in fiscal year 2000 out of roughly 60,000 who were sentenced. So this is only 1/6 more or less of the total number of people sentenced. For most situations, either some congressional enactment, a mandatory minimum sentence for a drug offense, or some operation of the guidelines didn't afford the courts any discretionary opportunity. The other area in which we might expect or we might think that we would see a bit of disparity would be in the rates of departure. If the guidelines command sentencing, we might ask whether judges are, for example, preferentially departing more frequently in white-collar cases than they are in street crime cases. That would be the third chart I have, again, crime type, title, rate of departure. And there again, there are some variations amongst the various types. But when I went and pulled this data down, I was actually fairly comfortably surprised to find that the rate of departure for robbery is not appreciably different from the rate of departure for fraud and embezzlement.
Fraud, you have 9.2%, robbery 12.7%.
That's right. So in 12% of the cases where the crime of conviction is robbery, nationwide, judges are departing from the guideline range.
Now, when you say depart, did you make a distinction, depart up or down?
These are downward departures.
All downward
there are so
departures.
few upward departures.
Gotcha. I just want to make sure I had the facts, that's all.
Okay. The data I'm reporting are for downward departures, and I should add, are exclusive of substantial assistance departures, which are the predominant method by which departures are found. A defendant provides substantial assistance to the government and then says,
right.
And then the government moves for a departure from the guidelines. These are departures for other reasons, ranging from extraordinary circumstances to...
I understand. I just want to make sure.
So taken together, these two pieces of data say to me, at least, that when judges are exercising some form of discretion or choice, they are winding up not making too much of a distinction in the way that they exercise and the frequency with which they exercise discretion between white-collar offenses and street crime, blue-collar offenses.
Gotcha.
And so that brings me back to the converse point, which is that then the disparity in sentencing, which remains in the chart above that, it's quite clear robbery sentences, drug trafficking sentences are getting substantially longer mean and median sentences than environmental sentences or antitrust sentences. Those must be the product of the operation of either statutory maximum or potentially the way the guidelines themselves are structured. I think, and I agree with Professor Bowman, that the amendments from 2001, which are designed to alter the way we calculate loss, may go some way towards changing that. And I agree as well that it's too early. The other point I would add is to the testimony of Mr. Skolnick. I wanted to make sure I said it right. Is I agree that that a large fraction of this is a lack of resources for these difficult cases. I'm not so sure that it is necessarily that we are focusing exclusively on street crime. I think sometimes we are also misfocusing our efforts within the white-collar crime area. Professor John Coffey has talked about the technicalization of criminal offenses and therefore the criminalization in areas which are more appropriately treated civilly. Plainly, the situations that we are discussing here today, the allegations against Enron, if proven, don't fit in that category. They are classic common law frauds that are and ought to be punished severely if indeed proven to be true. But part of it is that within this complex area, we sometimes misfocus the resources in areas where we are not being as effective. And I would urge this committee, this subcommittee, if it could do one thing, to try and ask the federal agencies responsible for criminal law enforcement to make a better effort at assessing their effectiveness, assessing whether or not their resources are being used productively in areas where, in effect, we are going to get the biggest bang for the buck. To date, we don't try and measure that. We never try and draw a line between enforcement and increased regulatory compliance, for example. We count beans, we count numbers of prosecutions, and as I said in my written testimony, that would be as if the Metropolitan Police Department counted murder indictments without ever asking whether or not they're actually lowering the murder rate. That's our goal. That's everybody's goal, is to deter crime and lower the incidence of white-collar offense. I thank you for the opportunity to testify.
Thank you very much. I think the last point you make is a very good point. But in fact, we do that all the time. We have Texas talking about the number of death penalties without ever examining whether or not they've impacted at all on the murder rate, which they haven't. So it's always an issue. I'd like to begin with you because Professor Rosenwald, I agree with the bulk of what you had to say. I'd like you to expand on what you did not spend enough time because of you're trying to accommodate me, and the distinction between you touched on it, but I'd like you to be more graphic, if you would. The distinction you make in your written statement between the type of white-collar offenses. The white-collar offense that is the one that basically the Enron type, which is, as you say, can be referred to as a definition of fraud by another name. And then the white-collar offenses, which you argue are quite different, and involves prosecutions for violation of rules and regulations that are part of a larger statutory structure, the regulatory state. Can you amplify on that a little bit?
Yes, I'd be happy to. What I have in mind is a trend that has grown increasing in the criminal law over roughly the last 50 years, in which we have seen basically a diminution of criminal standards of intent for some regulatory offenses, and an increasing trend towards prosecuting what I would perceive as technical violations to the detriment of looking at the more significant frauds. Later in the testimony, I cited one example where some of this is actually quite frequent, is in the Medicare fraud. There are plainly two types of Medicare fraud out there. There are instances, plainly, in which HMOs and individual doctors are deliberately lying about what services they're providing, taking federal money as a result, and when caught, they deserve, like any other thief, to be prosecuted in the same way. Contrast that, however, with many doctors, some of whom are leaving the profession because of this, who are genuinely confused as to proper coding. There are literally 100,000 pages of Medicare regulations. The average doctor gets 35 pounds of them on his desk each year, in which he's supposed to code correctly. The key, to my mind, to distinguishing between those lies in definitions of criminal intent. We have historically punished people with specific intent to do a wrongful act harshly, and they deserve such punishment. But increasingly, we have adopted rules of construction that presume for small businessmen, doctors, knowledge of the regulatory environment, and they, either through ignorance, mistake,
negligence,
fail to come up to snuff. And it's just, it's a bad use of our resources, first off, because the true frauds don't get prosecuted. I think it also diminishes respect, ultimately, for the criminal law, because we look at people who don't have that same degree of moral culpability and are equally deserving, are deserving of punishment. Dr. Virgo is not one of those people.
I appreciate the distinction. I think it's worth us keeping it in mind. I'd like to ask all of you to respond to now the various questions I'm going to. Each of you need not respond to every question, but you're welcome to if you'd like. Professor just indicated that depending on what crimes we pursue and how we pursue them, and what offenses we pursue, we either enhance, my phrase, or diminish respect for the law. I remember as a law student reading Jerome Frank's Law in the Modern Mind, and this notion of a judicial myth, and this idea that it matters that people think that the system is fair. It matters that people think that judges are totally objective. It matters when things occur intentionally or unintentionally that lead people to believe that neither exist, either that it's fair or that the judge is objective. And I think that applies here because the thing you most often hear stated, whether it's true or not, and I think the testimony of our last two witnesses indicate that disparity, at least at the federal level, is not nearly as as extreme as it is perceived by the average person. But leads me to, though, having held so many hearings over the years on criminal justice issues, how many times have we discussed this issue of prosecutorial discretion as it relates to plea bargaining? And what I'd like to raise with you all, particularly former and present prosecutors, and I'd start with you, sir, is there any data? Are there any data that indicate that white-collar prosecutions are either pled down considerably, allegations of white-collar crime, either indictments or even failure to seek indictments, are related to, are treated with any less diligence than drug-related crimes or crimes of violence or other economic crimes that occur as a consequence of, that we think of, the average person thinks of as non-white collar crime, burglary, robbery, etc. Can anyone comment on that?
Senator, I don't know if a data set exists on that, and I'm sure we can check and get back to you, but it ought not to happen. Under a long-standing Department of Justice policy, the guidelines are supposed to be as restrictive for the prosecutor as for the judge. And as I've told my people, if you don't like the guidelines, that's too bad. They should channel your discretion because you can't fact bargain and you can't charge bargain. The Department of Justice policy since the so-called Thornburg memo in 1989, which is still in force, is that you must charge the most serious, readily provable offense, and the plea must be to that offense, and all relevant conduct that is provable must be included in the sentence. So there shouldn't be any jacking around on the prosecutor's end, which is not to say it doesn't happen. But
I understand. It's an important point. Mr. Skolnick, you wanted to respond.
Yeah. I think the question is a very good one, Mr. Chairman. A lot of the data we seem to cite tends to be anecdotal, which may or may not be accurate in looking at the big picture. It's my impression at the state level that there are instances, and I can recall some from my own state, where prosecutors have been reluctant to take cases because of the significant burden that it would impose on them. And when we're talking about county prosecutors in many smaller communities, their staffs are really not that large. Oftentimes they even rely upon part-time deputy prosecutors. So I think from an anecdotal standpoint, it is my perception that if a state securities commissioner brings a county prosecutor a rather complex, resource-intensive securities fraud case, that you oftentimes will encounter some level of concern on the prosecutor, and they're probably going to wish that you would take it someplace else, if not to the federal level, maybe to a larger county.
Frank, you know, excuse me for saying Frank, Professor Bowman, you have been a state prosecutor and a federal prosecutor, and you know the federal system well. One of the things our former, or maybe one of you said, I'm not sure, the last panel or this panel, indicated that for good or for ill, sometimes we set a standard here. We raise sentencing guidelines, puts pressure in every state in the nation to raise sentencing guidelines because people come along and say, well, look, if this were in federal court, they'd go to... and sometimes I've been responsible for that, and it's had a positive effect, and sometimes it's not been as positive effect. And I'm sure it exists here, except the one place that I wonder about is, and I'm going to get to the resource question in a minute, and I'd like you all to speak to that. My impression, since I've just begun this, I don't have enough data to make the kind of case I would ordinarily make, or to make a judgment. My impression is that the allocation of resources at a federal level, even though they may be disproportionately low to other allocations of resources in the criminal justice system, and that's arguable, I want to get to that issue in a moment, are considerably more than they are at a state level. In most states. Now, I wonder whether or not, I mean, am I in the right track, Frank, or is that, or is your experience, or do you have any evidence from your academic endeavors to support that, or?
I have no data Senator, but I think your observation is undoubtedly correct as a generality. As I indicated in my written testimony, I was a Denver deputy district attorney in Denver for a number of years, and in fact, I was for a while the only person in the office who was specifically dedicated to doing anything remotely related to white-collar crime. And the basic attitude of my office and of the police department, and I'm not criticizing this, it's just the culture that prevails, was that paper crimes aren't real crime. They're civil matters, regardless of the intent involved and so forth and so on. Some of that's cultural, and it's understandable when you're in an office where the bulk of your work is and is perceived to be response to crimes like murder and rape and robbery, which have so much more emotional appeal. Part of that response has to do with a lack of expertise. Very few local prosecutors' offices have the expertise to engage in a complex white-collar prosecution. Part of that's sort of limitations on tax dollars that flow to them. Some of that probably is political in the sense that if you're an elected deputy or elected district attorney, the mileage is in the high-profile murder case and probably not in some relatively obscure group of financial crimes. But for a lot of reasons, all of which I'm sure you're very familiar with in your many years of work on this area, local prosecutors tend not to do this kind of work, and therefore it becomes particularly incumbent, in my view, on the federal government to take the lead, because in most places and most times we're the only game in town. For most local prosecutors, if they come across a big case and they really perceive that it has some criminal value, their instant reflex is to call the U.S. Attorney's Office and say, this is your job, guys, you take it.
That's my experience. My son was a federal prosecutor although he was on the criminal side in Philadelphia, which is a gigantic office, as you know, Mr. Comey. Gentleman sitting behind me was a federal prosecutor of the Justice Department for some extended period of time. One of the things I'd like to raise, and these are not accusations. I want to make it clear, because this is a dangerous. I quite frankly wrestled with whether to have this hearing in light of Enron and a lot of other things, because I don't want to. I want to be sober about this as I possibly can, which I hope I have been on other matters related to the criminal justice system. My impression is there's another factor, and I like you, Mr. Bowman, or anyone else, and I know, Professor, you may want to comment on that last point, and I'm going to, if you hold the thought, I just want to pursue this one piece. What are the reasons why local law enforcement, local prosecutors may not proceed and assume that it is a federal government's job? I raise this as a question. In some states, proceeding in localities, proceeding against the county's largest employer, proceeding against the county's most prominent citizen who has donated everything from the playground to the opera house, is a place where, especially since it is an uncharted area, not knowing how to proceed very well, is a place people tend not want to go. In my instinct tells me, I shouldn't say my observation, my instinct, because then people say, well, tell me which companies were proceeded against, but my instinct tells me. Is there, I'd like your opinions on that. Is there a sort of a limiting aspect to the instinct to proceed at a local level, or even at a statewide level? Now, it's one thing to proceed against for example, I bring down, I shouldn't say every year, but I bring down frequently the lead Medicare fraud folks we have at the Justice Department. We have one of the best, not at all related to my son, one of the best in Philadelphia. Really first-rate team. And they got one in California in the Southern District. And they're not just there, but there's some that are particularly well known and you use around the country, and I actually bring them down to do seminars for local law enforcement and for senior communities is what to look for. There's not a lot of reluctance to go after Dr. Smith, who has billed falsely, 3,000 mammograms or whatever. Okay. There is a reluctance to go after the XYZ hospital, which is sometimes the biggest employer in a community, in a city, in a county. And I wonder whether or not that plays. How would you guys factor this in? The reason I bother to ask you this, I'm not looking to indict local officials in any way, but figure out the resource allocation here. Should we be, for example, and just the context I'm asking this, should we be, for example, kind of like the crime bill, which you probably don't like, Heritage Foundation, should we be out there saying to local law enforcement and local prosecutors that we at a federal level, in order for you to assist so not everything bubbles up to us, we under a amendment to the crime bill, I'm not suggesting one, amendment to the crime bill will provide you X number of dollars to hire prosecutors to pursue white-collar crime? Or should we be saying to Main Justice, we want to enhance your budget so that we are going to increase the funding that provides you the ability to hire X number more prosecutors, investigators, or accountants, and the various technical people you need in order to be able to pursue white-collar crime. That's why I'm asking these questions, so you don't think it's just an exercise in futility here. To try to get the best sense of which way, and if at all, and maybe we shouldn't be doing anything more. Maybe we shouldn't be doing anything more. That is, we who sit up here, the Congress, in terms of either changing the penalties, changing the guidelines, changing the allocation of resources. And so that's why I asked the question. Sorry for the long prelude. So can you comment for me instinctively what you think based on your experience? Start with you, Frank, and then I know, Professor, you had something you wanted to say, and anyone else who wants to respond. If you have no response, that's okay too.
Two quick observations. One, I think your instinct that, again, as a broad generalization and supported by no data and only my own personal experience, one way or another, I've been either an actual full-time or special assistant U.S. attorney in 3 different districts and around the country, and I've been a deputy DA in Denver and so forth and so on. But based on my limited personal experience, I think your perception that local officials are sometimes feel constrained to bring white-collar and other types of cases, including, for example, public corruption, feel more constrained than perhaps their federal counterparts might. I think that is, as a generalization, probably not at all unfair. I think that federal prosecutors sometimes see themselves, I certainly did, as sort of the force of last resort to deal with sometimes locally intractable problems. So I think that your instinct is certainly consistent with my experience, though I can't prove that that's true. The second part of your question I take to be sort of, from a resource perspective, what would be the best thing to do if we had the money and the will to do it. My own sense is that certainly at the federal level, the federal effort would benefit from an increased allocation of resources. There is always, of course, the problem with which you are certainly more familiar than I of making sure that money that is appropriated in Congress is spent for the purpose for which you wish it spent. But I think there are some models historically with respect to the Department of Justice, indeed in the white-collar crime area, to which you might look. The additional sums that were allocated in the wake of the savings and loan scandal, and the additional sums that were allocated to beef up the healthcare fraud initiatives in the department. I'm not familiar with the specifics of the legislation, but my understanding is that certain restrictions were placed on how the department allocated those funds. And that is obviously a model to which one could look, although in this particular case, what we're talking about, it seems to me, is a somewhat broader question, white-collar crime more generally, and how you would craft that legislation, to get the money to the place you want it to go is beyond my competence. The last suggestion you make...
That's never slowed up any senator.
The last suggestion you make is an interesting one, which I had never thought of before, would be the notion of some sort of funding passing through the department or some other entity to states.
We've done it clearly in the violent crime side of the equation. We've done it clearly in other areas, so it's not unique.
I think that it sounds like a tremendously intriguing idea, and thinking completely off the top of my head and spontaneously, the only impediments perhaps that one might see are, at least in the violent crime area, if you're giving local prosecutors more money, you're giving them more money to do something they already know how to do.
Correct.
They know how to do it, they know how to train people to do it. If you give them more money to do something they don't know how to do, they may be a little bit more reluctant. And I also think that perhaps it may be difficult to give them sufficient funding to train and keep the kinds of people with the kinds of skills that you need to do this kind of crime and keep them over the long term. Because people who develop those kinds of skills become very valuable in the marketplace and may be easily drawn away from the relatively low-paid positions in local DA's offices.
Let me give you all a statistic and invite you all to comment on that point, but just a statistic that relates. When we passed the health care, some of us, there were about 5 of us who held extensive hearings in different committees during the late 80s and 90s about the extent of health care fraud, for example. And it is, depending on whose model you pick, it's somewhere well above $500 billion and as high as $1.1 billion. It's a lot of money. It's a lot of money. And some estimates indicate that the losses to fraud were as great as 10% of that. Let me be precise. I'm sorry. 99 healthcare expenditures in the United States were $1.1 trillion. I misspoke. And the estimates are that about 10% of that expenditure was a consequence of fraud. And so we passed an act that was called the Health Insurance Portability and Accountability Act in 1996, which made funds available for more FBI agents and attorneys designated specifically to investigate and prosecute healthcare fraud cases. We thought this may be a place for savings because we're worried about Medicare costs and the right. As a consequence, the FBI from 96 on increased the number of agents assigned healthcare fraud from 112, which there was in 1992, to 500 in 1999. The number of active healthcare fraud investigations increased from 592 to over 3,000. And the convictions increased from 116 to 548. Now, while these numbers are impressive, we should obviously be cautious about how we interpret this data in terms of relates to other things. But I cite that to indicate to you what most of you, I know you know, Mr. Comey, and others, that this is not the first time that this idea has crossed my mind about the possibility of how to do this. I think it's more complicated here. But it's just something I just wanted to raise with you. But does anyone want to comment on anything that's been said so far? Mr. Skolnick.
Mr. Chairman, I would like to comment on the question you asked regarding the possible reluctance of local prosecutors or investigators to take on a case when it may involve a prominent citizen or a corporate citizen within their community. It's my impression that local and state prosecutors or enforcement agencies are more apt to be constrained by a lack of resources than any local pressures in terms of why they don't bring a case. For example, I've always made it very clear to my staff that, we don't shy away from a case just because it involves a prominent member of the community or a local corporate citizen. And I think that's something generally law enforcement throughout the country does a very good job of doing. And if I may differ with my fellow Hoosier here, Professor Bowman, I do believe that if appropriately funded and provided adequate resources, local and state prosecutors and investigative agencies such as mine can do the job in terms of developing and investigating white-collar crime cases.
I would connect the two things you made, and again, invite comment on this, the two comments you made. I would connect the lack of resources and the reluctance to go after the big fella because you don't want to wound the bear. It's one thing if you go after somebody who is viewed as a charlatan in the community and is not responsible for the employment of a lot of people, and you're not sure you have the investigative tools to get the job done, but there's a tendency to be willing to start it. But what you don't want to do, if you don't have the investigative tools, if you don't have the resources, you sure in heck don't want to go after XYZ Corporation, which is where the corporate leadership sits on the board of the cathedral and the symphony and the whatever. That's all I meant. I wasn't suggesting that. I think that local prosecutors sit and say, "Oh my God," or regulators say, "Oh my God, I don't want to take on XYZ Corporation." I just think it is related to resources because, like I said, you just don't want to miss. If you miss with somebody who already doesn't have much standing in the community, then the criticism to you and your department is much less severe than if you take on, an entity that is a vaulted entity. That's all I meant. I wasn't going to motive about, resolve or political courage. Mr. Comey, you indicated, as you accurately stated, every U.S. Attorney's Office sets guidelines that direct its attorneys' prosecutorial decisions. For example, in many instances, these guidelines contain a dollar amount limits that effectively discourage prosecution or encourage, of economic crimes that result in dollar losses below a certain amount. And that's a legitimate thing for federal government to do. I mean, we shouldn't be handling every nickel-dime crime. I'm not suggesting that, but I want to make sure we know what we're talking about here. Say the dollar amount of $100,000, and investigators take their cues from investigators. Investigators take their cues from prosecutors' offices. If a case will not be prosecuted, you don't have the FBI or the local folks in that area investigating the case. So I'm concerned about the type and the number of cases that, as a consequence of decisions not to prosecute, potentially fall through the cracks, where it may be a case much bigger than $100,000, but if it just appears on the surface, that's the extent of the loss. The investigation that may uncover a greater cancer out there is not undertaken. So, $100,000 loss to the two people who were here in front of us today. Now, granted, they're part of a larger whole, but $100,000 loss to them is the beginning, middle, and end, of their existence in their view, but may not be significant enough to get us into the deal. It's these relatively smaller dollar amount frauds that are the most widespread out there. It's it's not, hopefully, pray God, it's not, we're going to not find out